Good afternoon, everyone, and welcome to our next webinar installment hosted by Nomence's Head of Accessibility, Ronny Hendricks. In today's webinar, Ronny is going to be looking at the legal perspective of accessibility, discussing regulations in the UK, the EU, and the US, and what you need to do to comply, and the information you'll need to provide. Ronny's going to look at the EU Accessibility Act, the ADA, Section 508, and the UK Public Sector Bodies Regulations, and how you can start working towards compliance and ensure you keep on track going into the future. As usual, please do join in with the discussion in the chat. Just make sure your chat settings are switched to everyone and not hosts and panelists. And that way, everyone can see your messages. And if you've got any questions, you can submit them using the Q&A function. And I'm going to run through as many as I can with Ronny at the end. Finally, we are using auto-generated captions from Rev today. There is a chance some of these might get a bit muddled live, but we will make sure that when the recording is uploaded to YouTube, that these are all tidied up and accurate. So yeah, without further ado, I will hand over to you, Ronny, to kick things off.
Awesome, thank you. Good morning, good afternoon, good evening, whatever you are. Welcome to our webinar today on the International Digital Accessibility Legislation, where we will be covering EU, UK, and US regulations. As Henry said, my name is Ronny Hendricks. I am Head of Accessibility at Nomence, and I'll be your host for today's session. So as the world becomes increasingly digital, it's more important than ever to ensure that all people have equal access to information and services online, especially for people with disabilities or other access needs who may face barriers accessing digital content that others might take for granted. Fortunately, many countries have recognized the importance of digital accessibility already and have put in place legislation to ensure that things like websites, mobile apps, and other digital content should be made accessible for everyone, regardless their access needs. Before we start, though, I do have a teeny little legal disclaimer to make. As the slide says, this webinar is for informational purposes only. I can and will not give you any legal advice, so always be sure to consult your own legal advisors for information concerning your specific situations. Having said that, let's have a look at what I'll be covering today. So in this webinar, we'll be taking a closer look at the digital accessibility legislations within the European Union, the United Kingdom, and the United States of America. I'll go through the key requirements of these laws so that at the end of this, you will have hopefully a better understanding of what applies to each area and the consequences of non-compliance. We'll end today's session with some best practices for you to start ensuring that digital accessibility will progress and that you're working towards legal compliance. First off, though, what do I mean when I'm talking about digital accessibility? To me, accessibility is about ensuring someone isn't blocked from completing a task or achieving a goal as a result of experiencing a disability. That means the aim is to eliminate barriers that prevent people from accessing digital content and services, and by doing so, everyone, regardless of access needs, can participate more fully in our society. And they should have an equitable access to information, education, employment, healthcare, you name it. So why should you implement digital accessibility? First off, and luckily the main reason our clients come to us for accessibility is because of what I've just explained. They think it's the right thing to do. But that's definitely not the only reason. There's others that positively affect other areas that are positively affected by accessibility, and any relevant for your business from a business perspective as well. So looking at a better user experience, for example, accessible websites provide a better user experience in general for all your users, not those with disabilities. So improving the user experience will or should also lead to an increased things like user engagement, loyalty, and client satisfaction. Because of the accessibility guidelines requirements, an accessible website will also work better on mobile devices, of which the usage only keeps rising year over year. Mobile devices have good accessibility support out of the box, so it's beneficial to leverage that. In terms of search engine optimization, a website that is built well and is built to be well understood by things like a screen reader will, as a result, also be better comprehensible by an SEO crawler like Google or Bing. Of course, it won't give you that first place ranking by itself, but it can sure help. We're also reaching a point where the aging generations have grown up using technology for at least a big part of their lives. They're used to browsing the web and making purchases online, and they also would like to retain that ability even when they physically might start experiencing a disability. With an accessible website, being a better website, you can also expect other business benefits. With the ability to reach a wider audience comes higher traffic, and a better experience comes higher conversion. So people with access needs that have a good experience on your website will also are very likely to share that positive experience with their peers, more so than others, because it's an exception to the norm, really. An accessible website also needs to be built well, meaning that it should also last longer and it should be easier to maintain down the road, reducing costs over time. And finally, there is, of course, a legal compliance. So as we will look at, there are legal requirements already in place that will likely require you to have a accessible website already. There's broader laws that cover discrimination and equal treatment, and website accessibility is covered by those as well. Besides that, more focused regulations have been written and are only made for stronger reasons to ensure that your website becomes accessible. Because nobody wants to have either user complaints coming in, let alone a subpoena to take you to court. Because as we'll see slightly later on, things like that get rather costly rather quickly. So something that is applicable in the majority of countries is the United Nations Convention on the Rights of Persons with Disabilities, the UNCRPD. The UNCRPD is an international agreement currently signed or ratified, I should say, by 186 countries around the world. Ratified meaning that they've agreed that the convention that they've agreed with what the convention says, and that they bind themselves to adhering to it. That is almost every country in the world. The biggest outlier in this ratification process being the United States, who have signed the convention but have not ratified it into their own laws, which basically means that they won't perform any actions that go against the convention, but they've also not legally committed to adhering to the convention specifically either. The CRPD sets out rights and protections for people with disabilities, and it was created to make sure that they are treated equally and with respect, and that they have the same opportunities as everyone else. The CRPD covers areas such as education, employment, non-discrimination, and also in Article 9, accessibility. Unfortunately, the process of making any claims on the convention is a somewhat lengthy and difficult one to go through, especially for an individual person. Mostly also because not all the countries allow individual processes at all. Only 103 of the 186 currently do, meaning you would need a bigger type of complaint crossing multiple people to be able to get a claim going. Furthermore, for people to be able to get a process going on the CRPD, they first need to exhaust any legal options on a national level, and only then can they move on. If they feel that the issue is still unresolved, move on and file a complaint with the committee. If the committee then accepts your complaint, the end result is a firm recommendation that your government is expected to implement, but they're not bound to it per se. So let's start looking at some of the accessibility regulations, starting with the European Union. So there are within the EU 2 directives that directly apply to web accessibility, namely the Web Accessibility Directive and the upcoming EU Accessibility Act. It's good to know and to understand, though, that the EU sets these directives as goals, and the individual member states need to transpose them into their own national laws themselves. And that also means that although most of those transpositions will have similar implementations, there might be slight nuances between member states in terms of additions or processes, country-specific exceptions, etc. The key requirements, however, are set in the directive, and they will need to be applied to each member state. Another thing to keep in mind is that these rules also apply to companies that are not based in, but do operate on the EU market, as they apply to websites and apps that are made available to the general public in the European Union. So if you're based in the United States, for example, but operate a website and deliver a service to EU customers, these rules, specifically the EU Accessibility Act, will apply to you still. The Web Accessibility Directive is the first directive we'll cover today. It came into force December 22nd, 2016, and as I've explained, it then still needed to be transposed into national law, which had to be done before September 23rd, 2018. And September 23rd is a recurring date in this sense that we'll come across a couple of times for the Web Accessibility Directive. So the focus of this directive is to ensure that the information from the public sector is available and accessible for everyone. It was also created to harmonize differencing digital standards surrounding web accessibility across individual member states, further ensuring that all EU citizens have equal access moving forward. The directive used a staggered approach of coming into force, which allowed public sector bodies to more gradually improve their accessibility on often already existing services, for example. So it started with the requirement that new services needed to be accessible by September 23rd, 2019. And then pre-existing services needed to comply by the same date in 2020. And then finally, mobile apps got covered by the Web Accessibility Directive, June 31st, 2021. So the requirements that public sector bodies needed to implement need to comply with are as follows. They need to publish a publicly available and accessibility statement following a model that was set out by the directive. Member states need to have a monitoring methodology in place to keep track of any progress on the implementation of the Web Accessibility Directive, and also to spur on organizations that are not improving their accessibility. They also need to report back to the EU every 3 years. And then websites and apps need to conform to the harmonized standard, which was called EN 301549, which is a standard that currently consists of WCAG 2.1 AA for web, with some additional extras and differences, also surrounding mobile apps, for example. The standard does get updated as soon as new versions of the Web Content Accessibility Guidelines are released. So when 2.2 hopefully comes into effect later this year, we're expecting, and the processes are already ongoing on making sure that this standard then gets updated to cover that as well. Have a quick detailed look at the accessibility statements, as they're one of the key pillars of the Web Accessibility Directive. They give visitors information on the accessibility of services that they want to use, and they should use that model format I mentioned. The model is also used for the monitoring process, so that we can make sure that all of the important information is presented in that statement. So the statement should state whether or what the current state of accessibility is, whether that state is known or not. So has an audit been done, and how does your website fare? Does it fully comply or not? It should also list what the inaccessible content is that is present, and it should guide people to accessible alternative for these items. Additionally, there should be a feedback and a complaint mechanism mentioned in there as well, because we want people to be able to contact you if they encounter an accessibility issue or need help with using the website. The complaint procedure is there to allow a way forward if people feel like they're not getting the response from you that they need or think they deserve. For the monitoring of the Web Accessibility Directive, each member state has assigned a monitoring body. These bodies have the authority to check on the quality of your accessibility statement and verify whether the information in there is accurate and complete. They also reach out to organizations that do not appear to be taking like adequate actions, and can provide support in those efforts. And they also have the ability to reprimand them if you feel like, or if they feel like you're not doing enough. Every 3 years, every member state has to also report back to the European Union Commission on the progress of the Accessibility Directive implementation. The initial reports since the directive came into effect are currently in, and the next round is expected to be in December 2024. And from then on, we hopefully can start seeing a trend on how much progress is really being made across the EU. So over the past weeks, some interesting news articles came out on seeing these monitoring bodies in action. The first instances showed up in Sweden, where DIG, the Agency for Digital Government in Sweden, has fined 2 public sector bodies with fines, one for about 60,000 euros and one for about 100,000 euros, for not taking enough action on improving accessibility in their services, which is a pretty substantial amount of money for any organization. And over in Norway, DIGDIR, their monitoring body, has started sending out warnings to public sector bodies, warning them that if they don't start coming into action, they will start fining organizations up to 435 euros ish a day. Let's have a look at exclusions from the directive. So it's important to note that the Web Accessibility Directive has some inclusions in place that currently don't need to be made accessible per se, but most of these will have caveats that go along with them as well. So Office files published prior to 2018 can be excluded, except when they are part of an active ongoing process within the public sector body, meaning that if they're still being used and relevant today, then they still need to be made accessible, even if they've been doing their rounds for over 5 years already. So live audio and video is also excluded. But if you publish this or record this and publish this afterwards, it will need things like transcripts and captions, as it would then be considered pre-recorded material instead. Online maps and mapping services are excluded, but you must provide essential information like a properly formatted and accessible address for maps that serve navigational purposes. So if you have a map on your website that points to your main office, it should also come with an address in text, for example. Some more, so third-party content. So if it's not funded or created by the public sector body, or you don't have like full control over it, it could be exempt. So an example of this could be the election results here in the Netherlands, where I'm based. The format of those files is often not accessible, but it's created elsewhere, and municipalities have the obligation to publish them. This often leads to the editorial web team to needing to make or create additional content to present election outcomes, for example, in an accessible format as well. So intranet and extranet content published before 2019 is excluded. So an intranet is basically a website for your internal organization, and an extranet is the same closed off web platform that is externally accessible by people outside of your organization, but not to the general public. So content on those platforms is excluded unless the platform undergoes substantial changes, like being replaced or redeveloped, because then it would be a new one and it would need to start complying. Content on websites and mobile applications qualifying as archives are also excluded, meaning that if they contain content that is no longer needed within an active administrative process, or it hasn't been updated or edited since September 23rd, 2019, then it's excluded. And the same similar thing goes for heritage collections. It's also exempt in situations where item preservation is in danger, or the original piece doesn't have enough contrast to begin with, for example. Also situations where it would require like a lot of manual effort because automatic digitization isn't available, and people would basically need to manually type over lots of documents that could automatically extract. That could exclude it from the Web Accessibility Directive as well. It's the countries might also exclude schools, kindergartens, and nurseries, except essential online administrative processes. So, for example, you should be able to accessibly sign up for these organizations online. That is mandatory, and public broadcasters are also exempt under the this directive, although they would fall under the European Accessibility Act, which we'll look at next. So the European Accessibility Act is the second piece of regulations we'll be looking at for the European Union. It goes into effect June 28th, 2025, and should have been transposed into national laws by now for all of the member states, but that hasn't happened in every member state yet. The Act sets functional accessibility requirements and has a focus on some key sectors that we'll go through shortly. These sectors were defined based on research and their importance to the general public, combined with some measurements on a high variety of different types of regulations across member states currently when it comes to accessibility. And this whole list will cover a wide range of products and services on the European market that it will apply to. So let's quickly go through the list that the Act covers. Looking at what is mentioned, the directive has some really in-depth definitions on these. And what is included and what are exemptions to these categories. So it is worth having either a read through the specific category in the Act itself, or if you think that it might cover your area of business, again, always consult with your legal advisor to make sure that you need to do what you need to do. So it covers computers and operating systems. It doesn't mean individual hardware, it means like physical computer, personal computer devices as a whole, as well as their operating systems like Windows, Mac OS, Linux, etc. ATM, ticketing, and check-in machines covers physical kiosk devices. For example, the ticket dispenser at your local train station should be operable, as well as an ATM to get cash out of the wall, or a payment device in a supermarket, for example. Smartphones should be accessible. Luckily, most of them are. On iOS and Android have very good accessibility capabilities. And if you're building apps for those platforms, then you should definitely leverage those as much as you can. TV equipment related to digital television services means like things like set-top boxes that you get from your television provider, but also the apps that they provide you with in the App Store to watch TV on your cell phone, for example. Telephony services and related equipment means that people have a right to equivalent access and choice, meaning that there should be options provided like real-time text or chat, or ways of having a video conference call, for example. Access to audio-visual media services. For that, people should be able to for example, be able to use their respective types of assistive technology on their set-top boxes. So there's additional devices that people can connect to it to, for example, get real-time subtitling, etc. And devices and services should support those kind of service or assistive technology. For transport services, air, bus, rail, water, it includes things like ticketing, of course, as we saw earlier, but also traffic information, whether that's real time through websites or apps, whether that's pre-journey or surrounding changes and cancellations during active traveling. That is all covered in there. In terms of banking services, this pertains to the services itself, but also to auxiliary requirements like personal identification, electronic signatures, and other payment services. Ebooks, when published, should be made accessible regardless of format. So you should be able to publish an ebook in an accessible format. likely the most well-known area the Accessibility Act covers will apply to the sector of e-commerce, and the directive defines e-commerce as a service provided at a distance. So you're doing it remotely through websites or mobile devices by electronic means. So you can purchase something without having to post something, and at the individual request of a consumer, with a view of concluding a consumer contract. So there has to be like a legally binding contract for this. As you can see, it does cover a wide range of areas. There are, however, as always, some caveats. So even though the Act sets functional requirements, it does not set a technical requirement. And the Web Content Accessibility Guidelines, WCAG, for example, is not mentioned specifically in there. The Act, however, does stay grounded in the WCAG's core principles, POUR, which stands for perceivable, operable, understandable, and robust. Those are specifically mentioned, and it refers back to that, to the Web Accessibility Directive and the harmonized EN 31549 standard in there as well. So the conclusion then can be that for websites and mobile apps, WCAG is the go-to standard for compliance. One of the biggest caveats would be the next one. The Act will only apply to newly marketed services and products. Although the definition on what that is and where that, it's not very clear whether it starts and ends. For example, if you have an e-commerce platform that was built and all of the products published before the Act comes into force, those would technically be exempt. But as soon as you then add a new product to your website, that would also mean that all of these surrounding processes, from browsing to checkout, would also instantaneously need to be made accessible, because they are part of that purchasing process for the new product. So my likely unsurprising recommendation for all of these is then, of course, to not wait too long and to start get moving. Member states might make temporary exceptions. There are no permanent exceptions, so if there's any, they will be temporary and will later down the line still need to comply. And it's good to know that micro enterprises, so small businesses, are exempt as well, meaning that if you have less than 10 employees and stay under like a €2 million revenue annually, you are technically exempt, although still urged and recommended to make your experience as accessible as you can. As soon as you go either over 10 employees or either like over 2 million revenue, you are no longer considered a micro enterprise and you need to comply to the Act. In terms of monitoring, there are some key things member states need to account for when implementing the Act. The first being compliance checks, similar to what we saw earlier with the Web Accessibility Directive. So personally, I have a bit of a hard time seeing this happening anytime soon. Member states are only now just starting to get into a position where they are actually thinking about and practicing the monitoring part of the public sector body progress on a somewhat manageable level. And so, yeah, not every member state even is at that stage yet. So the challenge on monitoring for this is already very big right now with the public sector bodies. So I don't see much happening on this front, unfortunately, for the first couple of years. Like besides the logistics and the sheer amount of websites and apps that we'll be dealing with just from an e-commerce perspective, and that's not even including all of the other areas that we've talked about. So all the more important, those are the next two steps, in my opinion, that are required. So a complaint process, again, must be in place for people to be able to contact you if they run into any accessibility issues. And companies must take reasonable action. So if you should be listening to people when they come to you, and you should be taking actions wherever you possibly can. Which goes back to doing the right thing in the end, of course, which is where we started our list. But there is legal consequences that still stand. So as soon as the implementation date is reached for June 25th, 2025, people will have the right to file a court case against you in their national courts. Making that legal step far more available than we saw with the UN Convention previously. Moving on to the accessibility regulations in the UK. There's two pieces that I wanted to quickly look at. That's the Equality Act of 2010 and the Public Sector Bodies Accessibility Regulations from 2018. One of the key pieces of web accessibility regulations in the UK is the Equality Act. It replaces several previous acts on sex discrimination, racial relations, and disability discrimination. It replaces those across the UK, with the exception of Northern Ireland. So the Equality Act casts a very wide net, and it states that UK goods and services providers, this includes both public and private sector organizations, have a legal obligation to not discriminate against people. There's a set of criteria in terms of protection, one of them being disability. So this covers people with various access needs. But the Equality Act says more than just don't discriminate. It also requires those providers, i.e. website owners, to actively provide an equal website experience to all their users. The Equality and Human Rights Commission published a code of practice to further clarify those responsibilities, from which the code is for, that is on the screen. It states that the duty to make responsible adjustments requires providers to take positive steps to ensure that disabled people can access services. That goes beyond simply avoiding discrimination and requires them to anticipate the needs of potential disabled customers and customers in general for reasonable adjustments. So to comply, website owners need to make those reasonable adjustments to make sure their web content can be accessed by people with access needs proactively. They can't just wait until someone comes asking a question or raises a complaint. The Accessibility or the Equality Act does not give a technical recommendation or a requirement in terms of standards to adhere to, but WCAG 2.1 AA being the globally recognized standard that it is safe to assume, and it would be in line with the next piece of regulations, which is the Public Sector Bodies Accessibility Regulations. Added a separate slide there. I'm going to shorten it, otherwise I had a hard time fitting it on the sheet. I can be very short on this one. It is the UK transposition of the Web Accessibility Directive. And although the UK has left the European Union, this is luckily one of the things that stayed unchanged. So the same goes, public sector body services need to be made accessible. The standard that they need to adhere to is WCAG 2.x. There's already been communications that currently it's 2.1 at level AA. But there's been communication from GDS already that as soon as 2.2 hits later this year, they will start mandating that within the year or like a year later from publication. So that's good to also proactively look at already if you get started with accessibility work on under this piece of regulation. So monitoring recently switched to the GDS, the Government Digital Service, and under these regulations, the same type of accessibility statement is required as well. So now that we've looked at the EU and UK regulations, there's one element I haven't touched upon yet that keeps raising questions for clients in both areas, really. And that is, what about disproportionate burden? So disproportionate burden is kind of a safeguard for organizations. It allows them to claim exemption for a website or a part of it from meeting the web accessibility requirements. It does still mean that the organization needs to look at reasonable adjustments, though. They can't just say, we can't make this accessible, so we're not going to. It means that excluding like a complete website is also rarely a valid claim, and the remaining parts of said website should still be made accessible. It's a bit of a tricky subject. Initially, it was quickly seen as like some kind of easy way out for some organizations, but claims were discarded as quickly as they came in, really. There are some considerations to take into account for claiming disproportionate burden. Those are mentioned in the Web Accessibility Directive, and they are that the size, resources, and the nature of the public sector body don't affect this or should be taken into consideration, and the estimated costs and benefits for both the public sector body and the benefits of people with disabilities need to be taken into consideration. There's no formal criteria set for those considerations, so it means that things like the difficulty to remediate a problem, the costs involved, and the benefits all need to be assessed and claimed on a case-by-case basis for each claim. It needs to go through an assessment that needs to be done, and that shows that both the benefits and the burdens associated with the claim. When making the claim, this assessment should also be published publicly and in an accessible format, of course. And it should mention, so the claim should also be mentioned in the relevant accessibility statement. And it should be linked directly to it from said statement. The monitoring body will check the validity of your claim, and they might rule against it. So this is yet another reminder of consulting with your legal advisor before making any such claims, seeing if they are assessed well and measured well. So let's move on to the other side of the ocean and quickly look at the accessibility laws in the United States of America. We'll be looking at two pieces here, being Section 508 and the Americans with Disabilities Act. First off, Section 508 of the Rehabilitation Act of 1973. So Section 508 was amended to this in 1998. And again, similar to what we saw with the Web Accessibility Directive, what it does in the European Union, Section 508 focuses on US federal agencies, so the overarching federal government. Section 508 states that those agencies and, pardon me, any government or non-government parties dealing with them must provide equal access to their electronic and information technologies. they should be made accessible for people. It also means that state or local government services are technically out of scope for Section 508, except when they need to deal with the federal government themselves. Section 508 does define a technical requirement, which is WCAG 2.0 at a AA level as the federal standard. It also mandates agencies to make sure that their procurement and processes procure accessible software as a result as well. The VPAT, a voluntary product accessibility template, is often used by a supplier in this case to demonstrate compliance. We could go much deeper into that. I won't for today, but those VPATs are a very useful tool, and honestly, I wish they were used broader across the globe as well, to be honest. So Section 508 also states that agencies must provide training to their employees so that they understand and deliver accessible products. And then last but not least, they are also required to report their progress twice a year to the Office of Management and Budget. And then what about Section 504? So Section 504 and Section 508 both address accessibility for people with access needs, but they are different in their scope and application. Section 504 prohibits discrimination against people with disabilities in any program or activity that is funded by the federal government. That includes a wide range of things like schools, universities, and hospitals, and other institutions. So Section 504 requires that these organizations provide equal access to their programs and services, including electronic and information technology. And Section 508 limits that scope more specifically to the federal government itself. Moving on to the Americans with Disability Act. So the ADA for short was written in 1990, and it prohibits discrimination against people with disabilities as well. It does so in a similar fashion to the Civil Rights Act of 1974 that it replaces, or adheres to, but it adds reasonable accommodations to the requirements, both for employees with disabilities, but it also covers basically all areas of public life. Per Title III in the Act, it imposes accessibility requirements for those public accommodations. Courts and the Department of Justice have interpreted the ADA to apply to websites as well, and they consider them public accommodation. Because the ADA does not explicitly mention web accessibility, but courts have ruled that websites should be made accessible. There's no technical requirement mentioned in there, but looking at court cases and rulings, WCAG 2.0 AA has proven to be sufficient, and that sits in line with their other with Section 508, as we just saw. So the ADA has led to lawsuits and settlements against businesses, and websites were found to be inaccessible. So as a result, it is important for organizations to ensure that their websites, or that they're at least working towards an accessible website to avoid legal liability. So let's have a quick look at some of those lawsuits across the three areas. And we'll see a remarkable difference there. So within the EU courts, I wasn't able to find any specific details on purely web accessibility focused cases, but as we saw earlier, both Sweden and Norway have been taking actions in monitoring and seeing how that goes. And with the European Accessibility Act deadline coming up for the private sector, we might start seeing a change in this sooner rather than later. So for UK courts, again, no cases under the Equality Act that have made it to court. There have been cases, but not made it to court. They've all been settled outside of court, mainly some cases by the Royal National Institute for the Blind. If we now look at US court cases, we see a stark difference. Both 2021 and 2022 saw close to 2,400 cases, mostly focused at consumer goods, services, and retail sectors, which was good for almost 1,400 of those 2,400 cases each year. Other areas include food, apparel, medical, tech, things like services, internet services. And it also includes companies that are based outside of the US but operate on the US market. Looking at some bigger cases over the past decade or two, we can see some big numbers in the US. Again, we see a lawsuit against Target, which costed $7 million or $6 million, sorry. One against Harvard for $1.6 million and Netflix for $250,000. There was also a much discussed case surrounding Domino's that took a long while and several courts to come to a conclusion. The plaintiff that filed it got awarded $4,000 in compensation. Two interesting facts there is that the court ruled that being able to call in an order does not provide equal access compared to using an app to place an order, which I found remarkable. And also that the legal fees for this case are currently unknown, but given the previously mentioned numbers, that $4,000 bill and the common situation where the losing party compensates any legal fees, the bill for Domino's will likely be much steeper than that $4,000. So what to do with this information and how to move accessibility forward? Let me first address a problem me and my international colleagues around the world have seen pop up more and more, and that's the usage, or the intended usage really, of a quote-unquote AI-driven accessibility solution, whether that's called a toolbar or an overlay, that can apparently magically fix everything for you. Unfortunately, we're definitely not at that stage yet, and a lot of accessibility issues require manual interpretation. The saying goes like, if it looks too good to be true, it probably is. We did our own research a year and a half ago showing an actual increase in accessibility in these issues on the specific website we retested with one of these tools. So instead, when it comes to compliance and working towards it, you will have to do the actual work and make better products that work for everyone. No, that does not mean that it has to be perfect straight away. And I think it can do even one better. Like, even an audit is nothing more than a moment in time. Yes, it will help you tremendously to know where you are and what you need to change to start fixing things. But an audit can be out of date within a matter of days, for better or for worse, depending on how much change you do on a regular basis to your system. So do the work step by step and document what you work. Document that you work on it and show that. So have a statement showing your progress and keep it up to date. Be responsive in a positive way to people reaching out with an issue that you might be unaware of. And those two steps alone can already save you a lot of trouble. Realize accessibility is a journey. So start creating that roadmap, assess where you are. And if you want to take a wider view, come talk to us for an accessibility assessment to get a better understanding on the baseline measurements on where you stand in regards to accessibility maturity and which areas you need to move on forward. Start raising awareness inside your organization so that people know what you're talking about when talking accessibility and how an accessible product is a better product and it benefits everyone. And finally, again, document your journey. Have a team and a place, not a team in place. You should have a team in place, but also have a team and a place in your organization that champions accessibility and that documents the step that you've taken and the things that you've learned. I always say people come and people go, so make sure their knowledge remains with you when they move on to go teach accessibility to someone else. And that's that. On that journey note, I'd like to end today's session. I would like to be your guide in all of this. So by all means, reach out to us, which you can do so on hello@nemensa.com. But that's my update for today. So let's see if there's any questions that have popped up in the chat that we could maybe answer on the back of this.
Awesome, thank you, Ronny. Yeah, so much useful information in there. I hope everyone watching has had a lot of their compliance questions answered, but I do see we have a couple in the Q&A box now, so we do have time for a couple, probably not all of them, but as Ronny said, if your question isn't answered, please drop us a line at hello@nemensa.com. So Ronny, we've got a question here from Marion, who asks, do you realistically think that the impact of the EAA in Europe will be the same as the status quo in the US, meaning increased lawsuits and large fine amounts?
No, and there's a stark difference between, I think, the way the legal system works within the EU and the US, and so like we're not used to those types of figures in terms of monetary fines. That's one thing, but going to court in let me speak for the Netherlands specifically, because that's the most I can probably give the most not legally binding legal advice on that. But going to court will mean that like a judge will say to you, like, okay, let's have a look at what kind of options you've already explored. Have you tried coming to an agreement? So even as an organization, you would need to be firmly put your foot down and say, like, no, we're not going to help you. We know we need to, but we're not, before a judge might allow a case to come to court. Where that process, at least from the outside, appears to be somewhat different in the US, where you could basically just get a subpoena on your doorstep, and surprise, you're in a court case. Not 100% sure if that's like, but that's what it looks like from the outside for sure. There's also looking at how these court cases come to be. There's a lot of repetition in terms of names and law firms associated with these lawsuits. I think over those like 2,400 cases that I mentioned, the top 5 of law firms associated with those cases, they're all the same. So they're like let's remove 500. So if there's 2,000 cases a year, those 5 each do a substantial amount of those. The same goes for the plaintiffs involved. So it's also questionable to whether those have people gone looking for trouble, because yeah, you'll find it and then you can file another case. Like, are they trying to make money or are they trying to do a better job. I'm between opinions there.
Awesome, thanks, Ronny. So I've probably got time for just one more. We have a question that's been submitted anonymously that asks, is there anything in the EU legal regulations specific to software use? For example, we've had a client recently say they wouldn't be able to get Figma due to legal reasons. Wondered if there's anything around accessibility or legal requirements that the UNCRPD had around software use.
There's legislation in terms of providing like the reasonable accommodations, and given that there are ways of making inaccessible software accessible, even if the developer itself isn't willing to cooperate. Not saying Figma isn't. I know they are, and they're actively trying to improve their accessibility, but like there's ways where you can make assistive technology work with existing programs. So I'd say, yeah, like someone that's working for you has at least the right to ask of you that you do your best to try and make a program work for them, or create a situation where that is possible in a reasonable way. I think that answers the question, hopefully.
Cool. Yeah, that sounds good. No, thank you, Ronny. That's brilliant. Really useful. Thanks to everyone that tuned in. We're going to have the recording available for you ASAP, so please do keep an eye on your emails when that pops up in your inbox. Our next webinar called Vulnerability, the Uncomfortable but Essential Business Skill, is taking place on the 25th of April. This is hosted by our principal UX consultant, Louisa Federico, who's going to talk about the ways in which you can be more vulnerable as an individual, team, or business leader in order to improve work culture and business outcomes. Sign-ups are now open, so you can find that over on our event page. Also, just want to give a quick plug for our free virtual web accessibility and digital inclusion conference virtually, which is taking place 16th to 18th of May. That's also on our Eventbrite. So please do sign up for that one if you enjoyed Ronny's webinar. There's been a few calls to ask whether the deck will be shared. I'm sure we can do that in our email follow-ups, Ronny.
Yep, no problem.
And yeah, thanks again, and we will we'll see you next time. Thank you.
Bye all.